I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're exploring what powers, if any, state officials in New York have to approve or veto the pending purchase of the Warner Brothers Discovery Studio by the media company Paramount Skydance, and whether New York's leaders, like the state attorney general, should use those powers. For more on those questions, we're joined by Phillip Berenbroick, who previously worked on the U.S. Senate Judiciary Committee's Antitrust Subcommittee and is now a senior strategist at the American Economic Liberties Project, a think tank and advocacy organization working on market concentration issues. Thanks so much for making the time, Phil.
Yeah, good to be with you.
So with the Trump administration signaling at least a willingness to approve this Hollywood mega merger, there has been increased scrutiny on the oversight powers of states' attorneys generals. So if New York does have any say in whether this merger will happen or what it might look like, where do those powers stem from? What would empower New York Attorney General Letitia James to get involved in something like this?
Yeah, no, it's a good question. So what we've seen over the last nearly year and a half is the Trump administration's Department of Justice and FTC have largely stepped away from enforcing the antitrust laws at the federal level. So state attorneys general have really had to step up. You've seen this recently with the Nexstar-Tegna merger, where states have challenged a deal that was approved by the Trump FCC and DOJ. You've also seen this currently going on right now in a courtroom where the DOJ walked away from the antitrust case against Live Nation Ticketmaster. So the states stepped in and are litigating that case right now. So here, you've got a transaction that the Trump administration has sort of all but signaled it's willing to wave through in order to benefit some of the president's friends and allies in the media space. This is the Ellison family, which controls Paramount Skydance. It's likely going to be up to the states to step in and investigate, and if they find problems, to litigate to block the Paramount Warner Brothers transaction. So states can sue under the federal antitrust statutes. They can defend their, and fight to protect their citizens under those statutes, the federal ones. And then certain states have state antitrust statutes. So New York has a statute called, I believe it's the Donnelly Act, which is, over 100 years old. So states can also sue in state courts using their own statutes. You saw this pretty recently in the Kroger-Albertsons merger. So states like Washington State sued in their own state courts to block that deal.
So I think about Hollywood studios, though, as a product of California. So what would allow New York to get involved or to even cite something like the Donnelly Act? Do they have to have offices in New York? Is it because these studios have projects in New York? What would allow New York to get involved?
Yeah, yes. So you would need some jurisdiction. So you have national and international markets here, but you also have state and local interests. So for instance, CBS, CNN have news studios in New York City. States like New York, fight and compete to attract film production to their state, to different cities around the state. So yeah, you would have. I don't think you would have any problem with jurisdiction issues. But yeah, I think states around the country would look at this and whether they have their own statutes or whether they would be enforcing the federal statutes.
And in terms of what a New York or California attorney general might be looking for out of something like this, is it about stopping the merger? Is it about concessions, whether it has to do with the movie productions that would be required moving forward, or something about the price of a streaming service that is a merger of Paramount Plus and HBO Max? What could they be looking for?
Yeah, so when you litigate one of these cases, usually what you're looking to do is to stop the transaction, to block the transaction, and keep the two companies as separate entities. Often, what companies will try to do in order to avoid litigating these cases is they'll try to offer concessions. But I think a key lesson that we've learned over the last 20 or 30 years in antitrust is that these types of concessions that companies often offer are are really difficult for the government to enforce. You end up putting, states attorneys general or the Department of Justice or the FTC and even courts in the position of really having to monitor the day-to-day operations of these companies, of becoming sort of compliance enforcers. And that's not really the job that a state attorney general or a judge wants to be in. They're in the job of either enforcing the law or applying the law. So, while I assume if states do challenge the case that the companies would try to come to the table and offer concessions, I think one of the key things to keep in mind is that those sorts of concessions are just really difficult to enforce, and the companies always have more information and strong incentives to sort of find loopholes and skirt them. So I would hope that enforcers would not rush to find concessions.
It seems like, though, that the recent history, at least, say with the first Trump administration experience and the merger of T-Mobile and Sprint, was to go down that route of a settlement. When you think about the capacity of a state attorney general, even if they're working in collaboration with some of their colleagues around the country, do they have the capacity to wage these types of battles? I mean, when we're talking about Paramount, Skydance, and Warner Brothers Discovery, I mean, these are big companies with some deep pockets and access to a lot of attorneys.
Yeah, I mean, resources are always a concern in any sort of litigation. Antitrust cases are very expensive to bring. But I think, states, especially some of the states with the larger offices. So, think of your New Yorks, your Californias, your Texases. Those states have proven really adept at bringing and litigating these types of cases. You've seen it in sort of the tech space, where states really, led the way with the Department of Justice under both Trump 1.0 and the Biden administration on types of cases against Google, against Facebook, against Apple, against Live Nation, Ticketmaster. And so, yeah, states do have this expertise. Some of them do have the resources, but those are things where it's important that state legislatures, fund the law enforcement efforts by state attorneys general. So that's something to keep in mind.
Do you think it's important if New York, for example, were to go after this merger or to try to exert some sort of concessions? Is it important that they have partners in something like this, or do you think they can be successful, or they can mount a meaningful challenge if they go it alone? Because I could see a world in which California basically makes the calculation, you know what, we ultimately think this will be beneficial for the Hollywood industry here, and maybe they've given enough concessions to Governor Gavin Newsom so that they all, peel back their critique of the deal. I mean, do you think New York can do this alone?
Yeah, I mean, I don't think I'd count on any state doing this alone. I think, state attorneys general really are adept at building and working in coalitions.
Mm-hmm.
You've seen this with some of the tech litigation. You saw this, you mentioned the Sprint T-Mobile litigation that state AGs led back in 2019. And so, states are really good at finding coalition partners and often bipartisan partners to bring these cases with. And that allows you to share and pool your resources. So, you've seen, I think New York has, said that, it's looking at this. State AGs tend to be pretty tight-lipped about investigations, similar to DOJ. A couple of the more outspoken ones you've seen, California AG Rob Bonta, talk about this case a little bit. I think you saw Colorado AG Phil Weiser talk about it a little bit. And so, yeah, I wouldn't expect states to go it alone. I would expect them to find coalition partners if they are going to bring a case. And frankly, like, this is an area that has spurred a lot of bipartisan interest. You saw this when this was a Netflix version of the deal. There was you had 11 Republican state AGs, write and talk about their concerns with consolidation in the media ecosystem. So this is an area with, I think, strong interest from the states and bipartisan interest from the states.
Well, what's the timeline then that you would expect some sort of action if state attorneys generals were going to get involved.
Yeah, I mean, I don't know precisely. I know that they are looking at this. First they have to collect the information from the parties. Typically then you interview a lot of different stakeholders in the ecosystem. So, I would assume states who are investigating this are talking to people like, people in the filmmaking world, people in the television world, cable companies that have to buy linear cable programming from these companies. They're probably talking to people who run and own movie theater chains, because there's a concern that you're going to have a reduction in theatrical output. So usually you're having those conversations to gather evidence, find potential witnesses, and then that would inform the type of complaint you could write. I think the companies, it looks like the end of this month is when they're likely to have their shareholder vote to try to close the deal. And then I think they've said they expected to formally close sometime in the third quarter. So obviously, it's important for if states are going to bring a case for them to file before the deal closes.
Well, finally, what do you think of the fact that it seems like whether this deal is going to get any scrutiny or serious scrutiny is contingent on the personalities and politics at play here, and it's not like it's something that is automatically triggering a review or what we would hope as some sort of objective assessment. I mean, is something like that even possible, or is this system that we have good enough and we just have to deal with the whims of who might be in power?
It's been since the Netflix deal was announced back in December, it's been a strange situation politically with this deal.
Hmm.
You saw the president sort of personally saying at the Kennedy Center Honors that he was personally going to be involved in the review of any deal for Warner Brothers. Larry Ellison, there's been reports that he had conversations with people at the White House about changes that Paramount would make at CNN. You had a congressional hearing, both in the House, and then Ted Sarandos from Netflix had to go up and testify in the Senate. There's going to be another hearing in the Senate. Usually these types of deals don't get two hearings. And you've seen Democrats on the Hill calling for a hearing with David Ellison. So, yeah, I mean, I think there are big personalities here. I think politics has gotten involved. But I think when state AGs look at these cases, I think they're gonna look at the facts and follow the law, and so that's sort of why we expect there to be why we think it's likely there's a legal challenge, because there's so many competition problems with this type of deal. But yeah, I think at the federal level, it's a little bit screwy right now.
Well, we've been speaking with Phillip Berenbroick. They are a senior strategist at the American Economic Liberties Project. Phillip, thank you so much for making the time. Really appreciate it.
Thanks, David.
Thanks for listening to today's edition of the Capitol Press Room. For an insider take on what's happening in state government, check out our Dispatches from Planet Albany show, available wherever you get podcasts or at capitolpressroom.org.
Join us again for Capitol Press Room, a production of WCNY Connected, Syracuse.